it's an element. I think it's just an enhancement. That's point number one for relevancy of the video. But if I heard it right, that video has a comment by Mr. Demons at the end that he's the victim of a drive-by shooting. That shoots a hole in the theme of The Last Witness.
No, absolutely. So Gene Rossi, great analysis. Tyler Bailey, also thank you. Great analysis for joining me. Stay tuned here at Law&Crime for the Law&Crime Daily. I'm Imran Ansari. Thank you for watching.
everyone, I'm Michelle Yu, and thanks for being here on Law and Crime with us. Our main focus right now is on the double murder trial involving rapper YNW Melly, happening down in Broward County, Florida. The defendant, whose real name is Jamell Demons, is charged with 2 counts of first-degree murder for the deaths of Anthony Williams and Christopher Thomas Jr. Williams, better known as YNW Sakchaser, and Thomas, who is also known as YNW Juvy, were shot and killed in October of 2018 in what the defense claims was a drive-by shooting. However, the state says it was the defendant who carried out the shooting, and both sides have officially rested their case, and the jury has been dismissed until Thursday when they return for closing arguments. Today, the defense called only one witness to testify in their case, and that was Adrian Davis, the defendant's friend since the 6th grade. Our very own Terry Austin was there and joins us outside the Broward County courtroom right now. Terry, good afternoon to you. As I just mentioned, the defense rested their case after only calling one witness, but they initially said that their case could last up to a week. Why was that, and were you surprised when they rested so quickly?
Well, I must say, Michelle, I was surprised. They had talked about calling FBI agent Brendan Collins to talk about those cell phones and the analysis that he was going to have as far as where they were at the time of the crime, but they've decided not to call him. Then they also talked about having a crime scene reconstructionist. That person was not called either, and they ended up calling the civilian, and this was a very important civilian. He was the individual who was in the red Mitsubishi along with 3 others, and so that makes him a witness to the crime. It makes him direct evidence, and he, along with Travion Glass, now are the 2 individuals who have testified about what they saw. And it was quite interesting. He basically said that Melly got in the red Mitsubishi at some point during that drive, and that was pivotal. And he ultimately said that Melly went back to his house along with everyone else in that red Mitsubishi. And so they got a call at some point that there was a shooting, and they were all quite upset. So I think that ultimately he did have some testimony that helped the defense. And right after that, as you mentioned, the defense rested. They called no other witnesses.
You mentioned it was a pivotal moment for Adrian Davis, talking about that red Mitsubishi car. What was the jury's reaction when they heard that testimony?
When he walked into the room, I saw a reaction from that jury. I know that they were expecting a witness or 2, but I don't think that they were expecting a civilian. I certainly don't think that they were expecting someone coming from the other car who was going to testify about that evening. They were watching him very closely, sitting on the edge of their seats, and they were watching what he had to say. When he mentioned, I looked up at the moment that he mentioned that Melly got into the car, they looked at him and sort of looked at each other, and there was a moment of, okay. So it was noted. Let's just put it like that. Obviously, I have no idea what the jury is thinking, but it did look as though they noticed, as did the rest of that courtroom, Michelle. They noticed that piece of evidence was a very pivotal piece of evidence as far as this trial is concerned.
Yeah, indeed. It was quite the reveal there in that courtroom today. Now, Terry, closing arguments are taking place on Thursday, and the jury will be sequestered. What can you tell us about that process?
Well, the judge said today that he was not going to be able to, or he didn't think that the parties would be able to have 4 hours each for their closings. He talked about we're having too much to do. We have to go through the jury instructions. We have to do the closing. So he ended up giving the prosecution 3 hours total, 2 initially for the first part. He called it the opening closing, and then 1 hour for the rebuttal. So you'll see the prosecution doing her opening closing, and then you'll see the defense doing their closing statement, and then as normal the prosecution will have their 1 hour rebuttal. There was some discussion, and there has not been a decision as to whether or not the jury charges will be done before the closings or after the closings. The judge said he normally likes to do it before the closings. That way everybody knows exactly what they can refer to. But he thinks there's going to be some problem with timing. So the defense essentially said, look, we can do our closings. We know what the jury instructions are going to be, and then you can do your instructions later. They want to try to get both closings done at the same time in the same period. They don't want to break up the days. The defense said, they were okay with doing the instructions later. The prosecution, on the other hand, said, look, I haven't made up my mind. I think maybe it's okay to do the instructions subsequent, but I might want you to do it beforehand, so let me think about that. So the prosecution is going to think about that, and I think the judge is going to make the ultimate decision whether or not it's going to come before or after the closings.
Also, at 1 p.m., parties began the charge conference. Were there any key moments in that stood out to you, or has it been really standard across the board, Terry?
Well, Judge Murphy likes to use the standard charges, and I think he knows that over the years, these have been ironed out by the courts here. And most of the charges they had already agreed to, and most of them were standard. At one point, the defense did say early on they wanted the words to the premeditated issue to say beyond a reasonable doubt, not just proven, but proven beyond a reasonable doubt. The judge said, no, let's do it just the way it's written in the charges. So they used that. There was also an issue about gang membership. The defense objected and said just because there were pictures of some of the defendants, Bortlen and Henry and Melly and some of the others, Juvy and Sakchaser and other people, actually. They talked about all these people wearing clothes that were red. There's no assumption, according to the defense, that those individuals are gang members, and he did not think that they should be able to have that sort of charge. The state then argued, look, this is standard. These charges are what that has been written already in the statutes, and the judge allowed it to come in. He said essentially that the jury could make up their mind. The last big issue as far as the charges are concerned is whether or not there's going to be a felony murder charge. The defense is saying, nope, there should not be. The state is saying, yes, there should be. The state is arguing that under the Pierce case, they should be able to state that the one murder that was done before this second murder constitutes the set of facts that you need for a felony murder, to say that one felony was being done in the commission of another. The defense is arguing, no, that's not the case. Not under Lynch. It should not be done. I don't know if you recall, Michelle, but we did see a similar fact pattern like this in the Parkland shooter, where the judge did allow the felony murder charges. So here in the state of Florida, I'm not certain that the judge is going to do that. He is reserving his decision. He is going to read both the Pierce and the Lynch case. He said he was familiar with the Pierce case, and he's going to reserve his decision, and then he will let the parties know, and then the parties will conform the jury charges based on his decision.
Terry, I want to address one more thing. Earlier this morning, we saw arguments outside the presence of the jury where the defense wanted to show the YNW documentary in full in front of the jury. The judge ruled that the full documentary would not be shown in front of the jury. Were you surprised that it wasn't allowed to air in full? Should the jury have seen it? What are your thoughts on that?
That one I wasn't surprised by. I think the judge probably made the right decision. I think the defense was lucky, frankly, that the prosecution put the documentary in the first place. It is mostly self-serving. It does show YNW Melly along with Sakchaser and Juvy, the two victims of this crime. It shows them all together working collaboratively. They are doing music, they are talking, they're laughing. And this was, shortly before they were shot and killed. And so it's very helpful, in my opinion, to the defense. What the prosecution wanted to show was at the very end of that video, it was saying, look, they were the target. So I think the prosecution was trying to say that Melly is admitting here that, he's the target of a drive-by, and somehow that's an admission. And the defense wanted the entire documentary in, and the prosecution said it was self-serving. And I think the judge agreed that it was self-serving and that it went in for the limited purpose that the prosecution wanted it in.
Terry, before we let you go, anything else that you can tell us about what we can expect out of closings on Thursday?
Well, I think one of the things the defense has tipped off the judge is their closing probably is not going to be that full 3 hours, and we'll see if that happens. I do know that Stuart Edelson, and not Adelson. We just learned that his pronunciation is a little bit different than the way we've been saying it all along. But the judge was also saying it the wrong way. But he did say he didn't think that his closing was going to be as long as 3 hours. You never know what's going to happen. The prosecution, on the other hand, she said, Ms. Bradley stated that she definitely thought she could use the time. She thought she wanted the 4 hours because essentially she was concerned about some objections that might be made by the defense, and that specific objection was as to the phone, the 9807 phone. She said she was going to be saying during her closing argument that that belonged to YNW Melly, and the defense said that's okay, you can say that because during our closings we're going to say there's no evidence directly to that issue. So the judge then said, okay, so perhaps you can do your closing in 3 hours, and so they ended up with everyone getting 3 hours, and the prosecution will be broken up into two parts as normal, and the defense will do their 3 hour closing after the first part of the prosecution.
All right, Terry Austin, fantastic information and fantastic analysis as always. Thank you so much. I'm sure we'll be hearing a lot from you when those closings begin on Thursday. We'll see you soon. All right, we're going to take a quick break here on Law and Crime, but there is so much more to cover on the YNW double murder case. We'll be right back. afternoon, and thanks for being with us on Law and Crime as we continue to follow the YNW Melly double murder trial down in South Florida. The defendant and South Florida rapper, whose real name is Jamell Demons, is charged with 2 counts of first-degree murder for the deaths of Anthony Williams and Christopher Thomas Jr. Both sides have rested today after the defense only called one witness to testify in their case, and that was Adrian Davis, the defendant's friend since 6th grade. Let's now recap some key moments of his testimony, and then we'll discuss it on the other side.
Let's start off with the first individual I named, Anthony Williams, also known as Seth. How did you meet him?
9th, 10th grade school.
How about Christopher Thomas? How did you meet him?
During school.
Bortlen or Cortlen Henry?
I met him in elementary.
How about Melly?
6th grade.
Trevon Glass?
Probably during school, 9th to 10th grade.
And his nickname was?
Fetty.
Jacoby Melly?
Since elementary.
Okay. And finally, Dontavius Withers.
Down here, Fort Lauderdale.
Okay. So you went to school with Williams, Thomas, Henry, Melly, Glass, and Mills. Is that correct?
Yes, sir.
At any time during school, did any of you have any problems with each other?
No, not at all.
Would you label yourself good friends, associates, close friends, or what?
Good friends, close friends, best friends.
And what was the purpose of going to the studio?
To make music.
Did anyone fall asleep at the studio?
Yes.
Who?
We all did.
That was from the day of smoking weed and having a few drinks.
Yeah.
Fair enough. Did any arguments occur between any of you at the studio?
Not at all.
Did there come a time that you all left the studio?
Yes.
Did you leave the studio earlier than what was scheduled?
Yeah, I believe so. So we were all in there asleep.
Will you tell the jury who got into the red Mitsubishi?
Me, Jacoby, Trayvon, and Tate, Dontravius.
Do you know who got into the Jeep?
Cortlen, Jamell, Seth, and Juvy.
Where were you going? Did anyone fall asleep in your car?
Yeah, we about all did except for the driver.
Did there come a time that you were woken up before you got to the house?
Yes.
What happened?
We pulled over, and that's when Melly got in the car with us.
Do you know where you pulled over?
And I don't really remember.
Were you woken up?
Yeah, but
Why?
it was like, because I was getting pushed over a little bit.
Were you woken up?
Yeah, but
Why?
it was like, because I was getting pushed over a little bit.
Okay. And are you 100% sure that this young man got into the red Mitsubishi?
Yes.
What happened to the Jeep?
I think they just kept going.
Did he have to unlock the door?
Yes.
Do you know who has the keys to Melly's house on October 26th in the early morning hours?
Jamell and Bortlen. They're the only one who had keys to the house.
Okay. Did you have a key to the house?
No.
Did Williams have a key to the house?
No.
Did Christopher Thomas have a key to the house?
No.
Did Trevon Glass have a key to the house?
No.
Did Jacoby Mills have a key to the house?
No.
And how about Dontavius Williams? Did he have a key?
No.
Okay, so the only two people you know who had a key to the house was this young man
Yes.
and Cortlen Henry.
Yes.
Did you see this young man unlock the door of the house?
Yes.
Who was the last person to get out of the red Mitsubishi to go inside the house?
Trayvon, he was in the cockpit asleep.
He was in the car asleep when you got to his house?
Yeah.
Did there come a time in the early morning hours that you were woken up and heard some distressing news?
Yes.
What did you hear?
That second Juvy was shot.
When you heard that, did you see Melly in the house?
Yes.
Did you see Melly how he was dressed in the house?
Yes.
What was he wearing?
Shorts and a t-shirt, I think.
Okay. Upon hearing that Sack and Juvy, and I really should use the correct names, Anthony Williams and Christopher Thomas, were shot. What did you guys do?
We were already dressed and stuff, so we just left with Fredo's house.
Was anybody upset or crying?
Yeah, we all were crying.
Was this young man crying?
Yes.
Are you sure of that?
Positive. And where'd you go? Fredo's house.
That would be Fredo Bang.
Yeah.
Do you know Fredo Bang's real name? Frederick Gibbons, by any chance?
Yeah, I think I've seen it.
Did there come a time after you got to the house of Fredo Bang that Cortlen Henry showed up?
Yes.
Did Cortlen Henry tell you what happened?
Yeah, he said it was a drive-by.
When Cortlen Henry arrived at Fredo Bang's house, was Melly there?
Yes.
Did you eventually leave that house?
Yes.
Approximately what time did you leave that house?
I really don't remember.
Where did you go?
Back to Jamell's house.
Who went with you?
Me, Trayvon, Jacoby, and Fetty.
By the way, when you first learned that Anthony Williams and Christopher Thomas were shot at the house with Melly, did anyone get on the phone?
Yeah.
Did anyone have any problem locating their phone?
Yes.
Who was that?
Jamell.
Tell this. What happened on October 25th and 26th to this particular prosecutor?
Yes.
Were any of us, any of the lawyers present?
Objection, relevance.
Same.
Did you tell the prosecutor when you spoke to the prosecutor? Were you under oath,
Yes.
sworn to tell the truth?
Yes.
Objection, proper bolstering.
Sustained.
Are you 100% sure that Melly got into the red Mitsubishi to go home?
Yes.
Are you 100% sure that this young man learned of the shooting of his friends at the exact same time you learned of it?
Yes.
And that was at the house?
Yes.
Are you 100% sure that when people were getting on the phone, that this young man was looking for his phone to call people?
Yes.
And that was quite the reveal, as there's a lot to absorb and chat about here, as I am now joined by our legal panel. We welcome in criminal defense attorney and former prosecutor Marie Pereira, as well as forensic psychiatrist Dr. Daniel Bober. Marie, I'm going to start with you here. One of the state's witness, Travion Glass, he never indicated that Melly got into the red car on the night of the shooting. However, as you just saw, Adrian Davis has maintained the defendant did get into that red car. What are your thoughts, and how do you think the jury is reacting to hearing these conflicting statements?
The jury's going to look at it like they should. They're going to want to use some type of common sense. At the end of the day, they put on Adrian Davis to be sort of like an alibi witness to testify that the defendant was not in the vehicle where the murders took place. That for some reason, midstream, he got out of the car that he got into when they left the music studio and jumped into the red car, which means he wasn't there when this crime scene happened. The witness also testifies that he had keys to the house and only a few people have keys, the defendant being one of them. So he had to not had been at that crime scene. But the problem here is this smoking gun sort of reasonable doubt witness that the defense has put on is a former friend. He lived at the same house with Jamell Demons, rent-free, and he has an incentive to lie. So his testimony is not a smoking gun, reasonable doubt, I'm not guilty type testimony, because there's room to say he's a biased witness. And then also the fact that he chose maybe not to testify, he doesn't have to testify, but the jurors are going to want to know, why did you get into one car and then conveniently get out into another car in the middle of the road? These are the problems I see with this witness that they're putting on basically to say, slam dunk, he didn't do it.
Well, that brings me to my next question here, Dr. Bober. The witness, Adrian Davis, has known the defendant since elementary school. I mean, is there any indication he might not be telling the whole truth here during his questioning? And why do you think that is?
Well, I think the ties run deep there, and so it's difficult to know what motivations there are. But again, we have a lot of circumstantial evidence. We have a lot of conflicting statements. And I think at the end of the day, that raises reasonable doubt for the jury. This case is by no means a slam dunk on either side, and I think we've seen a lot of inconsistencies.
Now, Marie, we heard testimony of the aftermath on Melly's reaction to hearing about the deaths of Sakchaser and Juvy, and we heard Melly had trouble locating his phone. What are your impressions on that tidbit, and do you find Adrian Davis to be credible?
I don't find him to be credible just based off the nature of their relationship. He was a groupie who lived rent-free in the man's house, and that was his homeboy. So yes, he has incentive to lie. He's not an unbiased witness. It's not like sort of like an alibi type testimony where he was seen at a 7-Eleven during the time of the murders independently on camera. This is a biased witness.
Dr. Bober, you're a psychiatrist. Melly has said prior in a documentary that he grew up in a rough neighborhood. I mean, do you think that has anything to do with the defendant's demeanor or even his actions after the shooting? I mean, witnesses saw him acting, I guess, happy during a music video shoot that followed after the day of the shooting?
I think that a lot of people that grow up in this environment have a lot of trauma, and so they learn certain coping skills to deal with it. And a lot of them have very broken homes. And so the only loyalty, the only brotherhood, if you will, is between them and their friends. So they have a different way of looking at the world, which if any of us were exposed to the violence and the trauma that they have been exposed to, I think we would develop a similar set of skills to learn how to survive in the neighborhood.
All right, yeah, it'll be interesting to see what the jury thinks, because that's certainly a big bomb reveal there today in court. Great discussion so far, guys. We're going to take another quick break here, but we're going to break down more testimony, and we'll have more trial coverage of the YNW Melly double murder trial in a moment. Stay with us. back to Law and Crime Network. We continue our coverage in the YNW Melly double murder trial. Prior to the break, we heard the direct examination of Adrian Davis, the defendant's friend since the 6th grade. But now I want us to take a listen to the cross, and then we'll chat about it.
Mr. Davis, you said you're 100% sure that Mr. Demons found out at the same time you did.
Yes.
No questions about that. You're sure he was at that house.
Yes.
And you were upstairs?
Yes, ma'am.
He was downstairs.
Yes.
But you're sure he was there. You could see him.
Mm-hmm.
Is that a yes?
Yes.
And you are 100% sure his phone was missing.
Yes.
Where in the statement on May 5th did you ever say that?
Objection.
This objection.
It was never asked.
Thank you. Counsel, so I guess the objection is improper impeachment, so rephrase your question. I just think
So,
objection.
you met with me on May 5th, 2022. You remember that?
Yes.
And you remember sitting down, you were present. That's a yes?
Yes.
Your two attorneys were present that you brought. That's a yes?
Yes.
And I asked you questions for quite a number of hours. Do you remember that?
Yes.
Okay. And do you remember being asked if you had met with anyone else with regards to this case?
Yes.
Okay. And do you remember being asked if you had met prior to speaking with me with the attorney sitting over to my left?
Yes.
Okay.
I didn't know who they were, and my lawyers told you that.
Okay.
I didn't know their names.
But you remember meeting with them?
Yeah.
Okay. And do you remember asking and being asked a question about what you talked about with them?
Yes.
Did you remember what you told them?
No.
Do you remember what you told them now?
Yes.
So are you telling this jury that when you were speaking with me, you forgot?
As in, what I'm telling them now, as of right now, yes.
So on the phone on that, do you remember if Mr. Demons had a passcode on his cell phone back then?
I don't think so.
You don't think so? And in terms of, would you be surprised to find that there was one on that cell phone?
No.
Did you know the passcode?
I don't think so. I don't even remember if he had one. We all use this phone sometimes. We all use each other's phones.
So you would use his cell phone? Why?
Talk to females.
You pretend you had to get women because you couldn't get them on your own?
Objection.
Why would you use his phone then?
Let me rule before you ask the next question, all right? It's overruled. Go ahead, answer your question. Go ahead, ask the next question.
So, with regards to your living situation there, you were not paying any rent, right?
Oh, man.
And nobody was paying any rent in that house except for the defendant.
Yeah, I'm pretty sure.
So, do you remember that evening driving to the studio?
Yes.
You remember who was in which car?
On the way there, yes.
And you remember who was on each car on the way back?
Yes.
Okay. Were there any threats that were made to anyone that night?
No, ma'am.
Did anyone have any other conversations or discussions about threats from outside parties?
No, ma'am.
Is anyone worried about their safety?
No, ma'am. But Melly's a rapper, you know, he's always going to be a target.
I'm sorry.
I said he's a rapper, so he's always going to be a target.
Okay. And do you remember stopping on the side of the road?
Yes.
Where did you stop?
I don't remember. It's like flashes and blinks, drinking and smoking, so I just know we stopped.
You know you stopped.
Yeah.
Okay. And do you remember if that was on a highway?
Not at all.
Okay. Do you remember if it was on a divided 4-lane road?
No, ma'am.
Do you remember if you guys were using GPS to get home?
No, ma'am.
Okay. Do you remember if you knew the route home?
No.
Okay. Do you remember what phone number you had back then?
No, ma'am.
You don't remember your phone number?
5 years ago, so.
Okay. Do you remember if you were awake or asleep?
I just told you. We were asleep.
You were asleep.
Yeah.
And you said you were intoxicated?
You didn't answer out loud.
Yes.
Do you know why the car stopped?
No.
Do you have any conversations or messages with the defendant?
No, ma'am.
Did you have a phone call with him?
No, ma'am.
When you stopped, was the gray Jeep in front of the red Mitsubishi?
Yeah, I believe so.
Have you ever answered that question differently?
I don't think so.
If I were to show you your statement from May 5th of 2022, would that help you in answering if you'd ever said something different than what you just testified in court?
Yeah, probably.
Okay, approaching with page 33 of the statement, counsel. Will you just read silently to yourself?
Yeah. I basically told you I don't remember.
Okay, so now your answer is I don't remember if the Jeep was in front or the Mitsubishi was in front.
If you watched the video, they put off first, so
So you watched the video.
you showed it to me.
In terms of the trial, have you been watching that online?
No, ma'am.
In terms of when you got home, you mentioned that you said Mr. Demons went to his room.
Yes.
Have you ever answered that question differently?
No.
Okay. On May 5th, 2022, remember that statement?
Mm-hmm.
At that point, did you say, I don't know where he went? And I assume his room.
I don't know.
You don't know. But looking at your statement, help refresh your recollection on that?
Yes.
Okay, page 34, lines 12 and 13, counsel.
Yeah.
Okay, so did you previously give a different statement that you didn't know where he went and you were assuming he went to his room?
Yeah. He went in his room.
So with regards to the car, you're saying that you got pushed over when somebody got in the car?
Yeah.
Okay. And with regards to being pushed over, did you wake up when that happened?
Like it was flashes. Like, yeah, I guess you could say I woke up.
Okay. And did they move you over or climb over you?
I don't remember.
Have you ever made a statement different than that?
I don't know. I can't remember.
Okay. Again, page 33. Question was asked: did they climb over to get you to the middle, over you to get to the middle of the back seat? Your answer was, I think I was at the window, so no. I think they might have climbed over me.
Okay.
So, is it your testimony that somebody climbed over you, or you pushed over,
I mean,
or that you don't remember?
yeah, I don't really remember.
You don't really remember.
Yeah.
Okay. And in terms of the phone, right? Did you see anyone get into that gray Jeep?
No.
You remember going to Frito Bank's house?
Yes.
Okay. And you remember seeing the defendant there? Is that a yes?
Yeah, he was there with us.
And you remember leaving there afterwards?
Yes.
And you remember going back to the defendant's house?
Yes.
Okay. And you remember at that point that when you went back to the defendant's house, it was you, Travion Glass, or Fetty, and Jacoby Mouse. That's it?
Yes, I believe so.
Okay. And you said that you were in and out of sleep and intoxicated.
Yes.
And in terms of the, you remember that Travion was the last person to get out of the car?
Yeah, I believe so, yes.
You believe so, or do you remember? Which is it?
Yes.
And you know, and you mentioned about Mr. Demons looking for his phone, right?
Yes.
So of course he used your phone to call it and try and find it, right?
I don't remember.
You don't remember how he was trying to find his phone?
Just in the house looking for it, just like you would do if you lost yours.
So he didn't, try and do Find My iPhone or anything like that. Of course he used yours to do that, right?
I don't remember.
Of course he used something like, an Apple iWatch and set it up.
Objection, there's no testimony that he had
I
it.
don't remember.
Excuse me.
Okay.
One at a time. You asked the question. Objection notice. Overruled.
So of course he did all that. He went on Find My iPhone and he's looking for it.
I don't know. I don't remember.
You don't remember. Okay. And of course he is using everybody else's phone to try and find it.
I don't know.
You don't remember. Okay. But conveniently the phone's missing that morning.
Objection to the
Sustained.
form.
Yes.
I sustain the objection.
So with regards to your conversation. You had texted back and forth with the defendant prior to this event occurring, right?
Yes.
And he had sent you a picture of his driver's license from that phone number.
Yes.
Oh. So you knew Mr. Demons, the defendant, Melly, to use that cell phone, 772-713-9807.
I don't know what the numbers is.
You have them saved in your phone, right?
Yeah, but I can't just remember that phone number like that from that number. But
Oh. And your testimony is that he's looking all over the house.
yeah,
So in terms of the phone, did you see it again that day?
I don't remember.
Don't remember. Okay. And in terms of the phone traveling up to the video shoot up in Cocoa, you don't know how the phone got up there.
I don't know.
And you didn't shoot Mr. Williams or Mr. Thomas, right?
No.
Okay. But you know who we're talking about, right?
Chris and Anthony.
Yes. And in terms of the messages and things for Mr. Henry, you're aware that his phone was broken at that time, right?
I don't know.
You don't know.
I don't know.
In terms of Mr. Demons, you know he was dating Mariah Hamilton.
Yeah.
Okay. And you know that Mr. Demons would FaceTime her on a regular basis.
Objection.
What's the objection?
There's no evidence of that.
I don't know.
So you know, and Mr. Demons would,
Excuse me, use the correct name.
Mr. Demons, my apologies. Mr. Demons would FaceTime and video chat frequently.
Yes, that's what you got a phone for.
All right, so we just heard the prosecutor hammer the witness about the statements he made to prior of May of 2022. What does our legal panel think of all of this? Well, find out after this break. We'll be right back. our Law and Crime studios here in New York. So before the break, we heard the prosecutor hammer Adrian Davis about the statements he made in May of 2022, where he never mentioned Melly was in the other vehicle or that he even saw Melly go to his room. And all of that had our legal panel's ears perk up as they are itching to give us their thoughts. Former prosecutor and criminal defense attorney Marie Pereira and forensic psychiatrist Dr. Daniel Bober back with me. Marie, what did you make of that snippet of the cross, and how is that going to affect the witness's credibility?
I think she attacked his credibility quite well. She got him to admit and impeach him with his own written words from a prior statement where he said he wasn't sure if Mr. Demons was in the house. And then now he's saying, I 100% was sure he was in the house. And I think that her cross-examination was quite effective. And at the end of the day, I think that prosecution has a problem because they're going to have a problem proving that Mr. Demons is the one that committed this murder based on the facts that I've seen, even with the effective cross-examination of the defense witness.
And Dr. Bober, we saw the prosecutor make a snarky comment along the lines of, did you use Melly's phone because you couldn't get women yourself? Now, what does that say about the prosecutor's professionalism here, if anything, and do you think that will affect the jury in any way?
You know, it's difficult to know how these things are interpreted, but I think sometimes prosecutors and defense attorneys will do that to throw witnesses off balance, to anger them, to make them lose their focus, especially when they're trying to impeach their credibility. So I think it's a risky tactic, and I think some people will be offended by it and turned off by it, or some people may even find it amusing and entertaining. So it really depends on who's viewing it, I think.
Marie, during the redirect, the defense attorney says lead detective Mark Moretti never spoke to Adrian Davis. Why do you think that is, and was that an oversight from investigators?
I think it maybe was an oversight, but it certainly shows that there was some shoddy police work there, because at the end of the day, we're not here to just single on one person and investigate that one person. We're here for justice. So if there was anyone else that could have disproven the fact that the accused is the one that did it, they should have called that person as well.
All right, Dr. Bober, very quickly, as the jury watches this, do you think they may react and feel, because of loyalty and the close bond that he had with Melly, that Adrian Davis may be making all of this up and not be trustworthy?
Yeah, I mean, I think that's a tremendous incentive to lie, right? When you think about the people that are closest to us in our lives and what we would do for them if they were in a situation like this. So yeah, I do think that.
All right. Well, Marie and Dr. Bober, this hour flew by. Thank you so much for your great analysis and insight. We hope to see you both again soon. But don't go anywhere, because we have plenty of more YNW Melly double murder trial coverage here on Law and Crime. We will be right back. Stay with us. Hi, everyone. I'm Michelle Yu, and thanks for joining us this hour on Law and Crime Network. We are taking a quick moment away from the YNW Melly double murder trial to discuss the trial of former Border Patrol agent Ronald Burgos Aviles. He was charged and convicted on 2 counts of first-degree murder for the deaths of his 1-year-old son Dominic and the child's mother, Griselda Hernandez. Now, Hernandez had a prior sexual relationship with the defendant that produced a child, and that was baby Dominic. Burgos Aviles was living with another woman at the time of the murders whom he had children with. The motive behind the murders? Child support after the defendant was served papers at his place of work. The Webb County jury in Texas took just about 9 hours to sentence the defendant to life in prison. Let's now recap what happened in that Texas courtroom when the verdict was read aloud.
On punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal acts of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson. Answers to special issue number 2. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of the jury. Verdict on punishment as to count number 2. Special issue number 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal acts of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson of the jury. As to special issue number 2. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of this jury.
All right, joining me to discuss this verdict is criminal defense attorney Natalie Whittingham-Burrell. And Natalie, what was your reaction when the jury came back and voted unanimously to give the defendant life without parole as opposed to the death penalty?
I was surprised, actually, just given the nature of the offense, that this is a parent on a child, where a parent is convicted of killing a child and his ex or his mistress, however you want to put it, all over child support. I myself am not an advocate of the death penalty. It's just that where the death penalty is legal, you would think that the death of a child alone would be enough to aggravate to the death penalty. And so I'm just genuinely surprised.
Were you shocked on how long the decision making took to return with a verdict?
No, I guess, you want them to have some consideration about it and take their time to think about it. That they took their time to deliberate, no, but that this was their ultimate outcome, that was surprising to me.
All right, well, Natalie, I want us now to recap some key moments from the penalty phase closing arguments. We're going to take a listen and then we'll talk about it.
Listen, the state of Texas did not create this situation. We didn't create the facts or the circumstances or the evidence. As hard as he tried to disturb, to stage, to alter the crime scene, we found it. Now we're handing you the baton. We've brought it to you. What did Dr. Fernandez say? The person who did this had knowledge. The person who did this had knowledge. This man had the knowledge. And what did I say in opening about clarity? After those 27 stab wounds and killing this innocent mother, he walks the 20 yards over to the stroller, gets in front of this little baby, and it's like he's looking in the mirror, Mr. Boggs. He's looking right at himself. And he opens that buckle, takes the little phone out of his hands, puts it down, picks him up, takes him over to the grass, lays him down, picks up the shirt. He wanted to get it right. He picks up this one of Dominic's favorite shirts. And he pierces, aiming for his heart. And he doesn't stop there. He doesn't stop there. When little baby Dominic is still alive, he goes for the jugular. How long did it take baby Dominic to die? With every beat of his heart, he would lose blood. What was going through his mind? Where's mommy? Where's my mommy? This man was a stranger, dude. He stabbed this poor lady 27 times. Don't you think that should be put into your formula somewhere? That he used a knife? He used a knife. That he cut his son's throat using a knife. Killing your own family member, does that go into your formula? No, that's not a variable that goes into consideration. The severity was not considered. When asked about the video interview to look at his behavior, you're a psychologist. Don't you think it's important to look at the behavior of the subject that you're going to opine on? Well, I fast forwarded that section. Come on, man. No, that's wrong.
Judge, objection. The state fast forwarded through their own video for this jury.
Never did, Your Honor. Never did. We brought you everything.
I don't want anyone to say that anything we've said excuses anything Ronald has said. All right? I'm in complete agreement with the district attorney. It is unforgivable. All right? No one is saying that excuse it, but it is a window into his moral blameworthiness. And you remember during your voir dire how these district attorneys all said you're going to answer a question about his moral blameworthiness. All right? Now, there's a difference between blame and moral blameworthiness. All right? He's blamed. You've convicted him. All right? He is blamed. There's no doubt about it. He's going to die in prison no matter what your individual choices are. He's blamed. But as you evaluate his moral blameworthiness, you have to think about what was going on in his head, just as what this district attorney did for Juan David Ortiz. It's the exact same logic. I'm asking you to use it. Now, you should also consider the district attorney's argument about the escapee that killed 5 people. And you remember he literally just referred to it 45 minutes ago. Well, you know, it doesn't happen much, but it does happen, and they could get out and they might kill a bunch of people, all right? Do you remember that escapee's record, Gonzalo Lopez? He had a decades-long history of criminal acts, right? That is nothing like Ronald Burgos Aviles. Nothing like Ronald Burgos Aviles. And again, I'm going to keep repeating it. I'm asking you to condemn the sin and not the man. Ronald is guilty, all right? Breaks my heart, all right? Breaks my heart to think that the man that I've been working with, that I've sat next to, that I know is guilty, it literally breaks my heart. But I'm going to say to you what we all wish that we could have said to Ronald on April 9th of that year, which is this: you don't have to do it. Okay? You don't have to do it. You don't have to do it. Ronald, you don't have to do it. Please condemn the sin and not the sinner. Vote with your conscience and follow your oath. We're all God's children, or none of us are God's children.
So there you have it. We just heard the prosecutor discuss the horror of these crimes. And Natalie, what do you think went through the jurors' minds hearing the facts of the case, but yet still voting to avoid the death penalty?
Well, the thing that I have to always keep in mind is that with the unanimity decision, where all of the jurors would have to make the determination that he would get the death penalty or life in prison, that is going to be ripe for dissent. The defense attorney only needs to find one person who has a moral compass that's going to say, I'm going to condemn the crime, but not the criminal. That's what he was calling upon, for them not to condemn his client to death. And so you just need one, as opposed to Demons, where they have a much lower number they need to get to in order to get to the death penalty. I think that's what this was a function of, was finding that one person or two or three people in there who, on their conscience, could not condemn the person. And then they also point to the fact that he didn't have a criminal record, which is, kind of ironic because he was, I think, if I remember correctly, in law enforcement. So I don't really think that makes it much better. But either way, that was a factor in his favor, mitigating it.
Meanwhile, the defense attorney argued to condemn the sin and not the man. What are your impressions of that? And do you think it had an effect on the jury?
I think it must have. He repeated it over and over again. I'm sure he mooted it with his colleagues. I'm sure he, put a lot of thought into using that as the theme of his closing argument in the sentencing phase. And I think that he was pulling on maybe some heartstrings there, maybe pulling on a judge not lest you be judged kind of religious underpinning when he said that we are all God's children. So I certainly think that he very deliberately used that in order to pull on the heartstrings of the jury. And like I said, he only needed one juror or two or three who would not go for the death penalty with that on their conscience.
All in all, just so sad, especially when you see a picture of the mother and the son, as that was put up just a couple of moments ago. All right, we have to take another quick commercial break here, but when we come back, we will have more trial coverage, including recapping for you what happened today in the YNW Melly double murder trial. We're back in a moment. You're watching Law and Crime.
are self-serving or intended to elicit sympathy as to his upbringing or anything of that nature. He admits to committing an arson of a forest in it. They left that in. So, Your Honor, it's completely self-serving. And for the purposes of sympathy, there's nothing on the issues in this case. It was introduced to limited portions of the state to show that the defendant had put out a statement indicating he was a victim of a drive-by and placing himself based on that documentary, which was released in December 2018, that he was a victim of a drive-by shooting.
Is that correct, Mr. Edson?
Mr. Howard would be able to.
Sure. Is that correct?
As to what the state's purpose for putting that in was?
No, as to what's contained in the rest of the video.
Oh, well, it's a documentary. Now, if there is a portion concerning arson of forests, we would take that out as well because we wouldn't want that in there. I didn't notice that to exist. But essentially, it's a documentary that the state introduced in order to demonstrate that Mr. Demons claimed it was a drive-by. It was a promotional documentary that was put out by his label, not by him. So it shouldn't have been introduced for that purpose because it's misleading as to attributing the statement at the end of the documentary to Mr. Demons. But beyond that, we think for sake of completeness, what the state did was edited portions that they wanted to put in, and we're asking to put the rest in absent any improperly prejudicial portions. And we'll take a look at it again to the extent that there's any reference to a forest arson. I missed that entirely, but we would be taking that out as well.
How long is the video?
I think the total was a 12-minute documentary. The state put in about 2.5 minutes of it, and with the edited portions, it's probably around 8 minutes or so.
Well, this, you have it here so they can play it?
It's here, and they have played it. They've seen it.
All right, so why don't you play it for me?
Sure. I don't know. But yeah, we would certainly be removing any arson admissions that we overlooked.
I am your favorite rapper. I don't care who the fuck you like. I am your favorite singer. I don't care who it is. I am. I watch every video they did, every mistake they made, every good thing they did, every sound they made. I know that shit. I know how to do it.
Documentary certainly gives us a better sense and deeper look in the life of Melly and his circle. The question is, should that have been admitted? Well, our Natalie Whittingham-Burrell will give us her thoughts after a quick break here on Law and Crime. Stay with us. Welcome back as we continue coverage of the YNW Melly murder trial. So prior to the break, we heard the defense say that they wanted to admit a longer portion of the documentary still edited into evidence. Now, this portion would have shown the interactions with the defendant's mother and grandmother and more on his background and childhood. So I want to get Natalie Whittingham-Burrell's thoughts here. She's our guest for today. Natalie, the state argued showing the documentary at a longer length would be self-serving, and they objected. What is your impression of that?
I actually think the prosecution is right here to the letter of the law. So there's a kind of paradox where the prosecution can get into statements of the defendant as statements against their own interests. So if I did it, obviously is against your own interest, and so you're the defendant and you make that statement, it's going to be reliable, even though it's an out-of-court statement being offered for the truth of the matter asserted. Here, they're offering these out-of-court statements by the defense of the defendant that are helpful to him. And so the reasoning in the law why that is not allowed is because he could, if he chose, get on the stand and testify and say all the things that he's saying in that video. So if they want to advance the defense with a positive statement from the defendant from before court, outside of court, then they need to have him get on the stand and testify to those matters.
As we both watched this documentary, Natalie, it really showed the dynamic between the defendant, YNW Melly, and the victims, Anthony Williams and Christopher Thomas Jr. I mean, do you think if the jury had seen this video, it would have shown the defendant in a different light? I mean, it seems like at the end of the day, he's just a young kid who wanted to make it big with his friends.
Yeah, I think it would have bolstered that even more, of course, and that's why the judge wouldn't let it in. He would have to testify. But it would have made him look more human, more loving, especially towards his mother. They did get a little bit of that with the portion that the prosecution put in. I think I was on here in Law&Crime and I said, you know, look, if I was the prosecution, I'm not sure I would even play that portion of the video that they played, because Melly looked like a sweetheart and he and his friends were getting along, two of which will go on to be killed. So I definitely think there's a benefit to Melly from some of the things that are on the video. And there's only one short portion that's hurtful, which is the little cryon that says he and his friends were involved in a drive-by shooting.
What about the statements made by his mother and grandmother? What did you think of that?
Oh, absolutely heartbreaking. I mean, the mother was still not fully an adult herself, but basically a child herself when she had him. The grandmother taking on the parental role to her own child and then to her grandchild. It seemed like they had a lot of hopes and dreams built up into him, that they really fed into his individual creativity and curiosity as a child. And now this is what it has turned into, the hopes and dreams of these two parents, basically. It's really, really sad to see, especially when we see how he now, immediately after this event was speaking to his mother. It's very sad to see that that's how this turned out.
Yes, it's sad to see how that relationship turned out. It seems it went a little bit sour. All right, I want us to now quickly listen to what happened in the courtroom as the judge asked YNW Melly if he wanted to testify in his own trial. Let's head back into that courtroom and hear it.
It's really amazing. I mean, I never thought that moment that
I guess, Mr. Demons, I need to talk to you, ask you a few questions, all right? You heard what your attorney said. He said he's resting. No further witnesses. Do you hear that?
Yes, sir.
All right, now, I don't know what discussions you had with your attorneys. You got competent lawyers there. I mean, you've seen them perform here. You've discussed things with them, I assume, correct?
Yes, sir.
And you understand that you have a right to testify, and you also have a right not to testify. Do you understand that?
Yes, sir.
You understand that if you do testify, I'm going to instruct the jury that they have to consider your testimony as they would any other witness. Do you understand that?
Yes, sir.
And if you don't testify, I'm going to instruct the jury that you have a right not to testify, and they can't consider that, hold that against you. Do you understand that?
Yes, sir.
So my question, I guess, is did you have enough time to talk about this issue about you testifying or not testifying? Did you have enough time to discuss that with your attorneys?
Yes, sir.
Did they answer all your questions?
Yes, sir.
And what is your decision?
I will not be testifying.
You will not be testifying?
No, sir.
Is anyone forcing you or coercing you to make this decision?
No, sir.
Anybody make any promises or on the contrary, make any threats to get you not to testify?
No, sir.
This is your free and voluntary decision?
Yes, sir.
Let me go further. You heard your attorney said he rests, he's not going to call any other witness. That includes you, but no other witnesses. You understand that?
Yes, sir.
Is there any other witnesses that you wanted your attorneys to call and present to the jury?
No, sir.
Any other evidence that you wanted your attorneys to present to this jury?
No, sir.
You good? You satisfied with their performance?
Yes, sir.
All right. And everything that you wanted the jury to hear and listen to is before the jury. Is that right?
Yes, sir.
So the decision was made and Melly decided that he will not be testifying in this case. We're going to take a quick break here and then discuss whether or not that was the right decision. We'll be right back. New York, we continue to cover the trial of YNW Melly, whose real name is Jamell Demons. And before we went to break, we just heard the defendant, YNW Melly, tell Judge John Murphy that he will not testify for his own defense in the trial. And with that, I want to bring in criminal defense attorney Natalie Whittingham-Burrell to discuss that with me. Natalie, are you surprised that YNW Melly chose not to testify?
Absolutely not. The way that the defense's case ended was actually very, very strong for them. Yesterday, Michelle, we were speaking and I said, I anticipate maybe the defense will call an alibi, but I really don't think that they have one. Well, I was wrong. They had an alibi. You end with your alibi. There's nothing your client can say then will be better than what a person says when they say, this guy wasn't there. He couldn't have committed the crime because he was with me and I wasn't there. Best possible evidence the defense could have had. And so they would only open Mr. Demons up to cross-examination by the prosecution, maybe getting into things in his past that they don't want the jury to hear about. Much better to keep him off the stand.
Yeah, and that would have definitely opened a whole other can of worms if that had happened. All right, Natalie, closings are slated for Thursday. What are you expecting out of the prosecution's closing, and how can the defense come back from all of this?
I expect the prosecution to hammer down on three things. Number one, the video of Melly getting into the backseat of the car. Number two, their crime scene reconstructionist saying that the victims were shot from inside in the backseat of the car. And number three, the text message from YNW Melly's cell phone saying that I did that, right? I expect them to go into that ad nauseum, replay things, put things back on the screen. I'm expecting PowerPoints. I'm expecting video presentations. From the defense, what I'm expecting is for them to hammer home all of the moments of reasonable doubt, how the prosecution jumped to conclusions in targeting YNW Melly at the exclusion of other potential suspects, and how they ignored YNW Melly's alibi witness who testified that he actually told the prosecution that he was with Melly at the time of the shooting and Melly was not the shooter. They are going to go in on that, and also calling into question, how could it be that we know this is Melly's phone when other people admittedly have used the phone, even when Melly has been incarcerated at other times? I don't know if that's going to be enough for the jury, but that's certainly something for them to work with such strong evidence from the prosecution in the way of that text message statement.
Now, Natalie, keep in mind the defense only called one witness in their case here. Do you think that was a mistake, or were they right to only call one witness since the burden is on the state here?
So the burden is on the state, and so you don't want to put up too much if you don't have to. I said from the beginning, it would have been great if they had an accident, a reconstructionist or crime scene reconstructionist who could question the strongest evidence, I think, other than the text message, which was the reconstruction. They didn't have that. So you can't present what you don't have. Their best evidence was the alibi. And I don't think that they should have called the phone records person who traced the phone to the scene of the shooting. Because if their story is that Melly left his phone behind, it doesn't matter where his phone was. He wasn't with his phone, so they didn't need to call that person. They kept it tight, and I think that that was a really good idea to keep it tight.
All right, Natalie, we have about 30 seconds left. Who you're leaning in favor towards now, the prosecution or the defense?
I started out leaning in favor towards the defense. I'm now leaning in favor towards the prosecution. Leaning. I don't know for sure. I'm just leaning there.
All right, Natalie Whittingham-Burrell, thank you so much for your great insight and analysis as usual. And of course, we are going to have wall-to-wall coverage as we continue our coverage of the YNW Melly trial down in Broward County, Florida. That would do it for us here. I'm Michelle Yu, but don't go anywhere because Law&Crime still has plenty of more trial coverage ahead. The Daily is up next. See you soon.